as I started to say, you know, I don't want to be redundant. I'm not going to talk about what I talked about in those two separate videos. You could review those videos on your own time. But the point I wanted to make in this session and in those videos is that there are a number of different ways of approaching research. I'm a big fan of using the topic and key number system. So whether you started with Jones or Hinkson, those of you who had the new trial issue, you had some really good head notes in those cases that would have led you to relevant cases. You know, the topic and key number system, as you know, it's vetted. Every head note from every case resides somewhere in that gigantic index of law. It's a way for you to make sure you got all of the cases from any particular jurisdiction classified to that minute point of law. So, you know, from Jones, you know, I ran a topic and key number search on the topic criminal law, topic number 110, key number 37, parens 2.1, which is what constitutes entrapment in general. But as I started to say a few minutes ago, there are other ways of approaching your research. What I want to do, and I want to get you to sort of move away from, is the tendency to simply run a relevance ranked search. You know, that's fine in the beginning. You know, if I were researching an employment discrimination issue, I could run a search like this from the home page, and Westlaw would give me the best documents that matched what I typed in. But the searches I'm talking about today are really going to be more Boolean related searches, terms and connectors. As I said a minute ago, I like topic and key number searches. In fact, I could start, even if I didn't have a case that had relevant head note that I could run a topic and key number search from, I could, from the home page, enter the topic and key number system. You know, so if, for example, I were researching it, you know, let's just focus on that entrapment issue for now. Entrapment, what was it? State of mind was one of the subsets for that issue. So, you know, I want to see if there is a relevant topic and key number on point with the defendant's state of mind when it comes to entrapment. And indeed there is. I mean, I could have just linked right to 110 key number 37 parens 4 and jumped off and gotten some good head notes from cases on this particular subject. So keep in mind that that is something you could always do. The other thing that I wanted to mention, that I'm not sure I really made this a point in those other videos I referenced. Once you've built a database, I mean, I've got 100 potentially highly relevant cases here. You know, I can actually just do a search within. You know, I could add terms to my topic and key number search here and knock it down even further. And I can filter. I know I talked about filtering in the video, but you know, that's a way for you to just start with a core group of potentially relevant cases, and through using those filtering techniques, drop it down even further. Those of you who are researching that Rule 33 motion for new trial issue, I didn't get to talk about this in the video. I did have a blurb in the handout about it, but I wanted to explain a couple of techniques here that would have helped you research that issue. Whenever you're researching statutes or working with court rules, you're always going to see notes of decisions. I mean, notes of decisions are cases that were vetted by editors, cases that substantially analyzed that statute, or in this case, that court rule, and editors thought they were important enough to place in the notes of decisions. And the other thing that they do for us that's really helpful, they create a table of contents. So, you know, if we're looking at obviously you know, you're looking at Rule 33 for newly discovered evidence, I can actually scroll through this list and maybe target exactly what, you know, what I need. I think diligence, newly discovered, oh, there we go, diligence and discovery. I knew I just saw it as I scrolled through. You know, if I wanted to get cases that discuss that for that specific point of law when it came to Rule 33, I could do that. Now, the thing that I do want to caution you with respect to notes of decisions, they're a wonderful starting point, but I also want you to really start looking at citing references when working with cases on Westlaw, statutes, regulations, court rules. The notes of decisions, that is not a complete list of every case that ever analyzed this particular rule. We got 2,200 cases in the notes of decisions, but there are actually 12,000. And that does include, that 12,000 does include the 2,266 that are in the notes of decisions. So if you actually wanted to start with citing references here, you could have done that. Now, if I were going to do this, what I would have advised you to do would have been to just first thing, knock it down by jurisdiction. Now, to save time, I'm not going to select Supreme Court. I'm going to just go with the Ninth Circuit here. And by the way, whenever you're filtering on Westlaw, make sure you have that select multiple feature checked off, because oftentimes when we filter, we apply more than one filter. And if you don't have that selected, you'd have to wait for the screen to refresh each time you make a choice before adding an additional choice. So make sure that's selected. You'll never have to worry about this again. But the point I wanted to make, there are 433 cases in the Ninth Circuit that discuss Rule 33. But how many of them mention, you know, affidavit in the same paragraph as due diligence? Due diligence. The phrase due diligence. You know, like I did with that topic in key number search a minute ago for the entrapment issue, I can actually add terms to a search like this and get it down to a much more manageable number. You know, in Hinkson, a couple of the Hinkson cases are listed. Perez, which hopefully you already have. You know, so that's another way of really starting with those known documents, and the information is there. The answers are here, you know, and I can, if I know what techniques I want to use, I can really get exactly what I need in a much quicker fashion. Let's talk about terms and connector searching at this point, because this is going to serve you well. And the next couple of searches I'm going to show you, you don't have on the handout. You do have other searches you could link to in the handout. I've put the hyperlinks in, but what I'm about to show you isn't in the handout. I'll put these searches in the chat because I did a couple of follow-up searches right before class. And this actually allows me to sort of show you another way of approaching research that kind of moves you away from this homepage. You know, if I was only interested in, federal cases out of the Ninth Circuit, I could just drill into, at this point, cases, and I could select, you know, Ninth Circuit at this point, and, you know, this would include all of the cases from all of the states in that particular circuit, you know, district court cases from, you know, Arizona, Alaska, etc. That's probably not where I would begin. I believe your case originated in California, if I recall correctly. So I think a better approach would have been to drill into cases, and then now that I drill into California cases, and then from this screen, I'll have an ability to just restrict to all California federal cases. Now you might be wondering, why am I doing that here as opposed to doing it on the home screen? Well, Couple of reasons. When you drill into an individual set, like we just did, an individual group of databases, in this case, these are all case law databases. When you click advanced, you actually have this nice template that gives you an ability and aids you in building a terms and connector search. Now, I already have a search pre-built because we don't have much time, so I wanted to sort of start with this particular search. I'm looking for cases that mention entrapped or entrapment in the same paragraph as defendant, which I want to be in the same grammatical sentence as either mind or predisposition or predispose. This is a pretty decent search to start with. But the other thing I wanted to point out to you that I should have mentioned from US v. Jones, US v. Jones, when we looked at head note number, I think it was, what was that, 11? It told us that in the topic and key number system, the head note, the entrapment has been classified to the topic criminal law 110, and the subtopic or key number is 37. That's what it is for entrapment in general. So what I wanted to show you here, I can actually add a topic and key number to a keyword search. So this is going to get me not only cases that mention entrapment, but also cases in the West topic and key number system that have been classified to the topic criminal law 110, key number 37, entrapment. Now, when you run this, the one drawback to a terms and connector search, keep in mind the difference between terms and connectors and a relevance range search. A relevance range search is going to give us the best documents on point. This is going to give us every single document that exactly matched what I typed in. I got 498. Now I'm going to tell you right away, most of these are probably not relevant. We're going to get cases of these 498 that might have mentioned this issue once in a footnote or once in dicta. And those are not going to be relevant. So how do you make sure you're getting how do you make sure you're getting all of the relevant cases on this particular issue? Well, the way that you're going to do it is by restricting to the summary of the case and the head notes. It's called the synopsis digest search. And the theory here is that if your issue is mentioned in the summary of the case or in the head notes, the synopsis or the digest, you know you're looking at a relevant case. And that's why I wanted to show you this advanced feature. Because if I click advanced, instead of having Westlaw search the entire text of every case looking for these terms, I can tell Westlaw, look, I only want cases that mention my terms in the synopsis or the digest. Now, when you do that, and I'm going to post this in chat so that you have this because this is not in the handout, you're going to knock it down dramatically, 185. Now, I could add additional cases or terms to this. This was pretty generic when you think about it. I can also sort by most cited as well as most used, and I want you to know the difference. Most used are going to be cases most used by commercial subscribers. Most cited would be listing the cases that have been used most frequently by other courts, by other cases. And I'm going to post this in chat so you have something to work with. Now, for those of you using the, researching the new trial issue, so this is I'm going to call this a sci-di search entrapment. There it is right there. Those of you researching the new trial issue, it's going to be a similar approach. I think I saved a search again. There we go. go with this one as a starting point. You know, I'm looking to get cases that mention the phrase new trial or the number 33, obviously, Federal Rule Criminal Procedure 33, in the same grammatical paragraph as either new or newly, same grammatical sentence as evidence, same grammatical paragraph as the phrase due diligence. Now, why am I saying grammatical paragraph? Well, on Westlaw, this is really another benefit to using terms and connectors on Westlaw. We index by grammatical sentence and grammatical paragraph. So whether your sentence is 5 words long or 50 words long, if it's 50 words long, it's going to be, we're considering that a grammatical sentence. What we don't do, if you type a /s, we don't behind the scenes say, well, the average sentence is 7 words long. I'm going to look for new within 7 of evidence. We're actually looking for those terms in the same grammatical sentence or paragraph, and thus your results are going to be much more relevant. All right, same problem here, right? I got 502. If I know that I want to run a synopsis digest search, I can just type that right here, SY, DI, and when I do that, I knock it down to 37. You know, and again, this is something, what you could do is maybe add, of these 37, how many of them mention, you know, affidavit? You know, did they do their due diligence in finding that affidavit prior to the trial? Knocked it down even further to 10. But, you know, side die searches are really an effective way for you to make sure you're getting every relevant case on a particular issue. And you know there's no other way of phrasing this particular issue. So this is going to be side die search new trial. Okay, a couple of other things. I've got a couple of minutes left. We started at 17 after. I said I'm going to get you out of here in 20 minutes. I can hang for questions after, but the other thing I wanted to point out in terms of approaches, I mean, I've given you a couple of other approaches. Another approach would be to utilize the safety nets that exist on Westlaw. You know, you might see research recommendations popping up from time to time. When you're in a folder, there we go, new recommendations are available, right? From time to time, you're going to see that pop up. If you're in a folder, this is why you always folder everything on Westlaw. When you folder items on Westlaw, it's going to break down the items in your folder and break down the common issues and point out additional documents that are not in the folder. So that's yet another way of making sure you got everything. 2 final tips. And both of these tips are more geared towards, you know, you're done researching, you've drafted your brief, or you're ready to submit your final. Quick check. Some of you use this with your open memo. Make sure you're running your documents through quick check. You know, before you submit your draft on, when is it? I think it's Friday, right? The 26th. You know, just upload to quick check. It's going to go through and recommend things that you might have missed. It's going to check your documents, the quotes you've used to make sure that your quotes are accurate. It's going to point out any differences. If you use the wrong page from a quote, it's going to alert you to that. The final thing, and this is something you don't have to worry about right now, when you're ready to submit the final version of your appellate brief, you're going to need to build a table of authorities. Now, if you're on Westlaw, you're going to have access to something called Drafting Assistant. When you go to Drafting Assistant, it will have a table of authorities builder. You just run the table of authorities builder. It will go through the brief, extract every case, statute, regulation, etc. that you cited, and it will let you build, it will automatically build the table of authorities. You just simply let it know where in your brief you want to place it, and it's going to give you that itemized list along with every page where you cited that particular resource. It's just a real huge time saver. And again, this is something you don't need to worry about right now. You're going to worry about that with your final version. But that is all I had for today. It looks like it's almost done. Here, I'll just show you what it looks like. Let me just place it here. And you'll see, once it inserts the TOA, this was a fairly lengthy brief. This is a Hark brief, and just giving you all that information. It's just a wonderful resource that saves you a number of hours from doing this manually. All right, that is all